Welcome to another podcast for legal research, writing, and analysis. This podcast is entitled Anatomy of a Trial. It will take you from the beginning, when you file a case, all the way to the end through the appeals process. Here you can see the federal court system. This is the chart from a previous podcast. At the bottom level, you see the district courts. In the middle, you see the circuit courts, and then finally the U.S. Supreme Court. You see here a pyramid with the trial or district court on the bottom, the appellate court in the middle, and the Supreme Court at the top. Essentially, this can be for either a state court system or a federal court system. But what I'd like to take a look at right now is the bottom level, or the trial court, and what happens in it. After you've spoken to your client and you realize you have a valid cause of action, you would file a complaint. A complaint is a type of pleading. The complaint and then the answer to the complaint are what we call pleadings. Then you proceed into the next phase of the case, which would be the discovery phase. This phase really lasts throughout the life of the case, and it's basically just an exchange of information between the two parties, or the evidence in the case. This can occur through interrogatories, through depositions of different witnesses or of the parties, and also through motions to produce evidence, things of that nature. Then we advance to the pretrial motion phase. Motions can be filed here for change of venue, or another example, motion to suppress evidence. But this is all of the preliminary matters that we have to take care of before we actually go to trial. At any of these phases, we can discuss settlement offers or plea bargaining. If a party accepts either a plea bargain or a settlement offer, that would conclude the case, and it obviously would not proceed to trial. If we can't settle the case and there's no plea bargain available, then the case would proceed to trial. There are two kinds of trials. There is a jury trial in which a jury presides over the proceedings, or there is a court trial in which the judge presides over the proceedings. In both of these types of trial, the evidence is presented. The evidence is presented through witnesses, through physical evidence, and then the jury determines what the facts are in the particular case. The judge then instructs the jury on the appropriate law to apply, and then the jury comes up with a verdict. The jury determines the facts, and the judge determines the applicable law. When we say that a jury determines the facts, what we mean is that the jurors sit and watch the witnesses. They listen to the testimony and the evidence that comes out of the witness's mouth. They watch the demeanor of the witnesses in court, and they determine what they believe to be the truth. What are the true facts in this case? At the conclusion of the testimony, the judge will determine what the applicable law is in the case, and then will instruct the jurors by giving them jury instructions. Then the jurors take the law that the judge has read to them, they apply it to the facts that they know to be true, and they come up with a verdict. The next phase of a case may be at the appellate level. If you lost in the lower court and you have valid grounds for appeal, then you would file that case in the appeals court, and you would then be called an appellant. The party who won in the lower court would be called the appellee. Note that an appeal is not the same thing in a trial. At the appellate level, the court is not going to rehear the evidence, but rather the court is limited to the evidence that was presented at trial. It has a court record that it will read, and it will hear your oral argument as well as read your appellate briefs and determine whether or not the lower court committed some type of error during the trial. There are various different grounds for appeal. One ground for appeal is legal error, that the judge improperly admitted evidence of some sort at trial. For example, if you gave a confession to the police and the police failed to read to you your Miranda rights, that confession would not be admissible since it was gotten in violation of the Constitution, and thus you would have grounds to appeal your conviction. Another type of legal error is if the judge reads incorrect jury instructions or the applicable law to the jury. And finally, a lack of sufficient evidence to support a guilty verdict. Another ground for an appeal would be juror misconduct during the trial phase. Use of experiments. For example, if there was testimony during the trial that a witness could see an accident from a particular location, and then one of the jurors went out to that location to see if the witness was telling the truth and that he actually could see the accident, well, then that may be grounds for an appeal. Similarly, drug abuse during deliberations by the jurors, or communications between the jurors and witnesses, or the jurors and lawyers. That's strictly prohibited, and that may also be grounds for an appeal. Another ground for appeal is ineffective assistance of counsel. This is difficult to prove, however, and there's a very high threshold of proof. Even if an attorney falls asleep during trial, this may not rise to the level of ineffective assistance. The party appealing must also show that this error affected the outcome of the case, that but for the error, there would be a different result in this case. If you lose in the appeals court, your court of last resort would be to appeal to the Supreme Court. Remember that this is a discretionary appeal, however. It's not an automatic appeal. So you would file a writ of certiorari, and the court would decide whether or not it would hear your case. This concludes the podcast for the Anatomy of a Case, from beginning to end.